since I don't have headphones, that should be out. And there should be no echo. There should be no echo. Someone please do inform me if there's still an echo. There's still an echo? Great. I thought I had taken care of that. No echo. Great. Okay. Would be that it'd be working, but YouTube had other plans in store for me. So as you see, I managed to get a few things done. I've got the chat up on the screen now. I think some people had questioned or had wanted to see the chat up on the screen. And I've got some notes here. I've got a little bit of an agenda so that I don't necessarily lose track. And so I think we can begin. No, we don't need to keep playing the music in the desktop in the background just in case anything goes wrong and I hit the wrong button. Okay. So, what happened? First, hi, I'm Leonard French. I am an actual copyright attorney, and this is my YouTube channel where I talk about legal issues that the internet faces, that technology faces, that copyright faces in 2017. So thank you for joining me, and let's get started. What happened was on Monday, a gentleman by the name of John Steele, who was the mastermind behind one of the biggest copyright scams in the 21st century, pled guilty to mail fraud and wire fraud, I think it is, from creating an enterprise where he would get copyrights to movies and then put them on the internet and then sue the people who downloaded them purportedly illegally. And so he made somewhere around $6 million. He and his associates made somewhere around $6 million suing people around the country for this purported copyright infringement. And that was about 4 years ago. I was involved in some of these cases, and so I thought I would talk about it. The indictment and the charges that were filed is kind of fun to read, so I figure I'll put it up on my screen here, put it up on your screen, and we'll talk about it. So let me do that. Let me go back to my agenda. Okay. Yes, okay. You're welcome to ask questions via the chat at any time, but I'm not always watching the chat during... Okay, thank you. See, that's what happens. If I read the chat, I forget what I'm saying. So if you're going to ask a question via chat, that's fine, but there's also going to be a question section at the end in case you want to ask questions then. Okay. How many hats do I have? A lot of hats. Okay, that's I didn't want that to be blue. I'm going to make this a little bit bigger and cover my face a little bit. Maybe we can, yeah, that's about right. So this is United States of America versus John L. Steele. And if I sound a little bit satisfied reading that, it's because I spoke to this man personally and had to try and decide for myself without knowing much of any of this, because this all came out afterward. I had to decide for myself and for clients who were actually in this situation whether his threats were credible and what to do about them. I have to be very careful about exposing any confidential information, so I'm going to speak very anecdotally. I'm not going to reveal any information that I think might lead to a specific person or a specific case. So I do apologize if anybody thinks I have to hold back. I'll tell you I'm holding back with something, but I don't think there's much I have to hold back with these cases. Most of the defendants that were involved in these cases remained anonymous. I didn't represent anyone who was not anonymous in one of these Prenda law cases, so I can speak generally about the matters and be completely safe with my professional responsibilities to my clients and to the profession in general. So again, I'm not going to be speaking in a manner about how horrible lawyers are, or no, John Steele is one bad lawyer. There are bad people in the world, and occasionally they become lawyers and do bad things. Or maybe they're already bad, or maybe the power goes to their head. I think maybe this is a case where someone was looking for some power, and this copyright stuff, as you've seen, is a source of power for some people. They can make this content and then issue strikes to people that they think infringe, and what are you going to do about it? How many of these cases actually go to court? So, the United States of America and John L. Steele agreed to resolve this case on the terms and conditions below. This is a plea agreement, so John Steele was charged with criminal charges, and that was in the District of Minnesota. I think that's where he lives and where he practices law. It was by the United States Attorney's Office and by the Department of Justice Computer Crimes and Intellectual Property Section. So this wasn't just one prosecutor that was after him. This was the Department of Justice, not something that happens very lightly. John Steele agrees to plead guilty to count 1 and count 17, charging him with conspiracy to commit mail fraud and wire fraud in violation of 18 U.S.C. 1349, and conspiracy to commit money laundering. He must comply with the terms of this agreement, or the remaining counts come back into play, and he'll have to answer for them in court and possibly be sentenced to something much harsher. The defendant admits the following facts. When we do a lot of these settlements that aren't for criminal matters, a lot of times the defendant makes no admission. So this being a criminal matter, thanks, Mark, hooray hat. And I do like to see how that shows up on the chat there, so give me a second. Cool. I've never used the browser source plugin for OBS before, so that was a new thing to me. So thank you. The defendant admits these facts, like openly and in court, and you'll see later he actually must stand by these facts, or else he's considered in violation of the agreement. He acknowledges that where he lacks direct knowledge of the facts, that the government has direct knowledge of the facts. So they're already preparing for any challenges that a clever lawyer may have. But here's the juicy part. Beginning in about 2011 and until about 2014, defendant Steele and co-defendant Paul Hansmeier executed a scheme to fraudulently obtain millions of dollars in copyright lawsuit settlements by deceiving state and federal courts throughout the country. The defendants used sham entities. They controlled themselves, and they obtained copyrights to pornographic movies, some of which they filmed themselves. The defendants then uploaded the movies to file-sharing websites, hoping to lure people to downloading their movies. When Steele and Hansmeier ensnared someone, they filed false and deceptive copyright claims that concealed their role in distributing the movies, as well as their significant personal stake in the outcome of the litigation. After fraudulently inducing courts to give them the power to subpoena internet service providers, the defendants used extortionate tactics to garner quick settlements from individuals who were unaware of the defendant's role in uploading the movie, and who were often either too embarrassed or could not afford to defend themselves. And that last part is absolutely true. Many defendants who find themselves as a recipient of this kind of case can't afford to fund a full defense. You saw what the bills were like in the H3H3 case. It's true that the bills in this case are a little bit, in a case like this, would be a little bit lower, but the bills would still be very high, in the 5 digits, more than $10,000, probably more than 20 or 30 to properly get through a case. Why is it? Well, maybe you've seen some of the complicated nature of the case from cases that federal litigation, the way it takes these twists and turns, and where you think it's going to be one simple issue that needs to be adjudicated, well, you have to do that through a complaint, and then a motion to dismiss the complaint, and then an answer to the complaint, and then a discovery process, etc., etc., etc. And even if your attorney is getting paid $200 an hour, which is a low amount for a copyright attorney these days, that adds up really quickly. One single filing could easily be 4 or 5 hours of work between actually researching and drafting a motion or a filing, and then actually doing the footwork to make the motion into something that's in a format in Word, and dealing with any technical issues for filing, so etc., etc., etc. After fraudulently... oh wait... When individuals did fight back, the defendants dismissed the lawsuits rather than risk their scheme being unearthed. Absolutely true. They would dismiss a lawsuit and then dare you to figure out what to do about it. Sometimes they would file a lawsuit in the wrong court so that they could get your subpoena. They could subpoena your internet service provider, get your identifying information. Then they would dismiss the case and deal with you separately. They didn't even have to have an active case going, because I think at one point one of the cases had several thousand defendants, and what they did was they would have one defendant who agreed to settle, but instead of a monetary settlement, they would have that person sign an agreement that looked good for the judge to grant the subpoena to thousands of other quote-unquote co-conspirators, and then that way they would get your, not only your information, but they would get all the information of those thousands of people as well, because those people were not going to, not all of them, the vast majority, were not going to put up a fight in a foreign court, in an out-of-state court. So finally, the courts began limiting the number of people that they could sue in one lawsuit. They changed tactics and began filing lawsuits falsely alleging violations of the Computer Fraud and Abuse Act. That some of their sham clients had been hacked and recruited, or that some of their sham clients had been hacked, and then they recruited the ruse defendants I was talking about to fraudulently obtain authority from the courts to subpoena the service providers. So beginning in or about September of 2010, and using their law firm, they monitored file sharing websites and obtained IP addresses of individuals who downloaded or attempted to download their clients' movies. They then filed copyright infringement lawsuits to obtain the John Doe identities from the courts. After receiving the subscriber information, they would finally, this is where it gets really bad, they would engage in these aggressive settlement tactics. They would make phone calls, they would send letters, they even at one point put defendants' information up on a website next to the list of movies that you allegedly downloaded in an attempt to coerce you into settlement, to encourage you to settle the case. They would use threats of the recovery of maximum statutory damages of $150,000 per infringement, which they would supposedly go after that if you didn't pay their modest settlement fees of only $3,000. But beginning in April of 2011, the defendants started to upload their own movies to BitTorrent file-sharing websites, including the Pirate Bay, without their clients' consent, and in order to entice people to download more of the movies. If there's more infringement, then we can sue more people, right? Well, the fact that they uploaded it themselves creates something called an implied license, and they wouldn't normally be able to sue if they have granted permission. So as a defense attorney, we would argue things like implied license, and the problem with arguing that they had uploaded the video to BitTorrent, prove it. I now have to go and subpoena an internet service provider on their end, find out what their list of IP addresses is, find out if any of those IP addresses match, and it's very possible that maybe they used an IP address from an internet service account that doesn't belong to them. Then I've got to investigate that IP address and conduct depositions and just conduct discovery of relevant evidence. And who's paying for all of this when there's a $3,000 settlement offer on the table? It's a cruel, cruel world when it comes to copyright law. Thus, defendants knowingly caused their clients' movies to be shared and distributed on BitTorrent websites and thereby purposefully allowed and authorized the BitTorrent users to obtain their clients' movies. Thereafter, despite colluding in the purported infringement of their clients' copyrights, Steele and Hansmeier caused lawsuits to be filed disingenuously. Disingenuously. That is a hard word for me to say. Alleging that the individuals purportedly downloaded their movie without authorization. For example, on or about April 1st, 2011, someone uploaded one movie which was owned by a client of the defendants, and after catching approximately 71 IP addresses, the defendants filed a lawsuit in Illinois court against all 71. The allegation was false and misleading because the defendants had implicitly authorized the downloading. It was also false and misleading for another reason that really doesn't need to be addressed here in the charges, but the courts do also have a standard for the location of where you can sue somebody, jurisdiction and venue. And so we don't know from those 71 IP addresses yet whether they're even in the court's jurisdiction. And the court can't issue a subpoena for the IP addresses outside its jurisdiction anymore. We have case precedent and case law that says that they have to use IP address geolocation services before deciding to sue an IP address. On or about April 29th, the defendants filed an ex parte motion seeking early discovery. This is normal. When you sue a John Doe, you don't know who the defendant is, so you have to ask the court's permission to uncover their identity. This breaks the rules of civil procedure, so you have to file a motion to allow you to break the rules of civil procedure. It's more complicated than that, but that's as best I can do in a short summary. Between April 2011 and December 2012, approximately 200 fraudulent copyright infringement lawsuits were filed throughout the country seeking subscriber information associated with more than 3,000 IP addresses based on the spurious allegation that these defendants were caught downloading either the one movie or another movie owned by the same company. After filing these lawsuits and filing the motions, the judges granted the early discovery, and after receiving the subscriber information, they would employ these same coercive tactics of pressured phone calls and emails and letters and putting information on a website about you. I remember one time they told me that they were going to take my client's house, and they were going to own my client's house and take it from them, and they would never see it again. And that's just not something that you're allowed to do as a demand in a copyright case, especially when the law doesn't really support taking someone's house. There was really no path to do that here without very specific circumstances that didn't happen. So that was very coercive to defendants who would hear those threats and take them very seriously because they didn't understand what was going on. After all, who understands file sharing websites and BitTorrent and all that? But either those of us that participate in it or those that created it maybe, but those are those participants too. So yeah, you really don't have too many lawyers or judges or anybody else that really knows much about BitTorrent. By lying to the courts in order to obtain subscriber information and deceiving subscribers, defendants fraudulently obtained numerous copyright settlement payments. And that's true. Let's see. I think John. I couldn't tell you whether it was John Steele or Paul Hansmeier or Paul Duffy, but I do remember calling their office once to get a copy of something that hadn't been put on the docket properly, and I was told to go screw myself in more colorful language than that. And that was when I discovered that John Steele and Paul Hansmeier and Paul Duffy were not operating their entity properly, their law firm properly. Defendants attempt to obscure their involvement in the scheme. In or about November of 2011, in order to distance themselves from the fraudulent copyright infringement lawsuits, defendants caused Prenda Law to be created. Although another attorney nominally owned, in name only, owned Prenda Law, it was Steele and Hansmeier who exerted control, including direction of employees, dispensation of finances. At various times, filing appearances for in connection with Prenda Law, they multiple times falsely denied any direct involvement with or control over Prenda Law. They also used names like the Anti-Piracy Law Group, and they represented sham defendants such as AF Holdings, Ingenuity 13, Guava, Livewire Holdings, LW Systems. I think I personally litigated against AF Holdings, Guava, and maybe a Livewire in there. I don't remember if it was an Ingenuity 13. I also remember another funny case, but it wasn't with Prenda Law, I don't think. But there was a case filed in Philadelphia court, in Pennsylvania State Court. And here, I'll take the document off. Pennsylvania State Court is not the right place for a copyright suit. But there was a enterprising attorney who saw an opportunity to exploit Pennsylvania law and try to obtain some of these John Doe subscribers' identities using Pennsylvania law instead of copyright law. And it didn't work. The case got removed to federal court, and the enterprising attorney dismissed the case. But I'm not sure how far it would have gone. Would there have been some kind of fallout from having tried to use state court to extract copyright settlements out of people? I don't know. So AF Holdings was one of them. They list them all. Ingenuity, Guava, Livewire. Beginning no later than May 2012, defendants filmed and caused to be filmed adult movies in order to further their fraudulent scheme. I'm sorry, I'm reading this dramatically because this is just so much fun for me. On at least 3 separate occasions in Chicago, Miami, and Las Vegas, Steele and Hansmeier contracted with adult film actresses and produced multiple short pornographic films. Afterwards, they caused Ingenuity 13 to obtain copyrights to the films, which bore the names 5 Fan Favorites and A Peek Behind the Scenes at the Show. They made no legitimate efforts to publicly distribute or commercially release the movies they filmed. Instead, they instructed their third party to upload the movies to file-sharing websites such as the Pirate Bay in order to catch, sue, and extract settlements out of people who attempted to download their movies. When they caught people downloading, they filed lawsuits, yada, yada, yada. We know that part. Then they invent hacking allegations. October 2012, after courts had begun limiting the early discovery that defendants could obtain, usually they would only obtain a name and address, and they'd no longer be allowed to have a phone number and an email, and they'd be limited. The court would specifically say only for the express purposes of settlement, only, for this case, etc. So they couldn't dismiss the case and then go and extract a settlement. They had to keep the case live. So they caused lawsuits to be filed on behalf of Guava LLC, falsely alleging that their clients' computer systems had been hacked. They would claim that usernames and passwords were shared, and that meant that was a violation of the Computer Fraud and Abuse Act, which is actually a criminal statute that has a civil component. If you can prove a criminal act was committed under the Computer Fraud and Abuse Act, you can sue the person civilly if you were damaged by that act. After the Guava lawsuits were filed, defendants filed the motions for early discovery. As far as defendants knew, the IP addresses listed in the Guava complaints and motions were IP addresses that defendants had caught downloading their or their clients' movies. In order to attempt to make the Guava lawsuits go more smoothly, they also recruited one or more ruse defendants who had already been caught. The ruse defendants agreed that in exchange for Steele and Hansmeier waiving a settlement payment, the ruse defendant would be sued and permit Steele and Hansmeier to seek discovery about his or her co-conspirators. Now, this violates a constitutional requirement. Cases and controversies. If you're a law student or if you follow, the legal world, courts cannot hear matters that do not involve a live case or controversy. And you'll hear courts throw out cases that are moot, where there is no longer a live injury that needs to be remedied or remedy that can right a wrong. If the court cannot effect meaningful action to these parties in this litigation, and I'm really paraphrasing here, then the judge has to dismiss the case as being moot, as there being no case or controversy. So having a ruse defendant settle a case and then moving forward with the case to allow a judgment to be entered is unethical, illegal, and criminal in this particular case. As defendants knew, the ruse defendants had not participated in any hacking activity, nor had they entered the computer systems with hacked usernames or passwords. In fact, the downloaded movies belonged to an entirely different entity. Nevertheless, they brought several lawsuits against these fictitious defendants and falsely alleged that they had participated or benefited from a non-existent cabal of hackers in order to attempt to obtain authority from a court to obtain subpoenas. Yes. Courts accuse the defendants, so then the cover-up begins. About early 2013, courts began scrutinizing the defendants' tactics. Upon uncovering certain parts of the facts described above, courts began denying the defendants' requests to subpoena internet service providers, dismissing lawsuits that the defendants had caused to be filed. On or about May 6, 2013, the Central District of California, which I believe was the one with the Star Trek decision, issued an order imposing sanctions against the defendants, finding that plaintiffs, including Steele and Hansmeier, have demonstrated their willingness to deceive not just this court, but other courts where they have appeared. Plaintiffs' representations about their operations, relationships, and financial interests have varied from feigned ignorance to misstatements and outright lies. But this deception was calculated so that the court would grant plaintiffs early discovery requests, allowing plaintiffs to identify defendants and exact settlements from them. With these granted requests, plaintiffs borrow the authority of the court to pressure settlement. That is also absolutely true. Us attorneys are considered an arm of the court, an officer of the court, and we are not allowed to abuse that authority, and the courts will smack us down if they catch us doing so. You can see the line of inquiry in the video from a few months ago about the attorney who showed up to court still intoxicated from his drinking the night before and having had some kind of a car accident that he then drove away from, and we don't know anything else. And the judge makes these inquiries not just because that's a reasonably suspicious thing to have happen in the first place, but also because this is an attorney who is not supposed to misrepresent things to the court and is not supposed to misrepresent the role of an attorney to clients by being drunk in a courtroom, which I have also seen happen with my own eyes and is not a pretty thing. The court imposed monetary sanctions in the form of awarding attorney's fees to the opposing party and referring Steele and Hansmeier to their state disciplinary bodies and notifying all judges overseeing all other copyright cases filed by defendants of the court's findings. In order to further evade detection and further their scheme and protect their illicit profits, defendants continued to lie about the following. On November 27th, 2012, there was a hearing in Sunlust Pictures v. Mr. Nguyen, and they purported to be a corporate representative of Sunlust. During the hearing, their representative falsely and misleadingly testified under oath that he did not know of another of the parties, when he in fact did, and when he was attending the hearing at the request of the woman named Sunny Leone, when in fact Steele had asked him to obtain the hearing. Wasn't Sunny Leone an adult entertainment actress? Okay. Just clearing that up there. On or about November 29th, 2012, ML was deposed in Guava versus Schuyler. This case I was involved in. I did not represent any of the named defendants, but even though this was a Cook County, Illinois court, there were still subpoenas being sent to Pennsylvania residents, and so I represented a couple defendants in that case. And so that case, here's what I didn't know happened, was that they were lying when they said that their representative was in charge of legal matters, that they had maintained computer systems to track the hackers, and that they had real copyrights that they were really prepared to sue over. I do not remember how many clients settled cases, and I have specifically not looked up how many cases were settled, but I'd say it was a half a dozen to a dozen, and they weren't all settled. There were, as soon as I got wind that there was vulnerability in these cases, I stopped settling cases with John Steele. However, there were a couple in there that got settled, and those defendants have a claim now against John Steele, but we'll get into that because there's something at the end here that's really great. On or about January 25th, 2013, Steele falsely and misleadingly informed the court that Guava had some computer equipment in Illinois and Las Vegas, and that certain unknown John Does had hacked into the computer equipment, when in fact Guava was a shell company and the defendant simply invented the hacking allegations in a complaint. Steele falsely and misleadingly denied that defendants had reached a deal with one of the victims, whereby the victim would waive the payment of a settlement, where they would waive the settlement fee for the victim, and the victim agreed to be sued. February 2013, defendants caused another perjury violation, misrepresenting that a person was a CEO of AF Holdings when he was not. March 6, 2013, Hansmeier was deposed and testified under oath that he had never worked for and had little association with Prenda law. Thank you, wainscoting. I don't know. Is it wainscoting? Wainscoting. Anyway. In fact, Hansmeier, along with Steele, exerted substantial control over Prenda law as well as its finances. Hansmeier further falsely and misleadingly testified that ML was responsible for creating AF Holdings when ML was not. In fact, it was Steele and Hansmeier that caused AF Holdings to be created and controlled and made decisions on behalf of AF Holdings. They signed things under penalty of perjury that they managed various adult content-related companies when they did not. And then defendants caused to falsely and misleadingly represent certified alternative dispute resolution policies with the name Saltmarsh, when no one had reviewed any policies or certifications with an entity named Saltmarsh. Just remember that name. It's coming up later, I think. May 2013, under penalty of perjury. Okay, good. AC had participated in a limited number of transactions when in fact Steele had used Alan Cooper. It was AC was Steele's gardener. So AC. So I guess I shouldn't. I don't know. I don't think that's confidential, but they referred to him with initials here. But AC was Steele's gardener, and he had him sign copyright documents. I think AC testified that. Here, let me take this off. I think AC testified that Steele had handed him a document to sign with another document underneath, and he doesn't know whether he signed the document he thought he was signing or whether he signed something else. No word on H3 yet. We're still waiting for the court to rule. There were some new updated filings that are just rehashing some of the old, not old, but some of the current motion for summary judgment filings that were made. I'm not going to go over those here because I haven't seen them. Anyway. BG, an attorney hired by Steele to oversee copyright litigation, was filed with the State Bar of California. August 26, 2013, defendants caused ML to sign an affidavit where ML falsely and misleadingly represented that membership interests in AF Holdings were held by a trust named Saltmarsh, whose sole beneficiaries are ML's unborn children, and that ML was AF Holdings' managing member. In fact, AF Holdings was controlled by Steele and Hansmeier, and ML merely served as a nominee to conceal the defendant's interests in the AF Holdings. Steele and Hansmeier caused ML to sign a notarized declaration under penalty of perjury that ML was the only manager, that neither Steele nor Hansmeier ever served as a director, that the only role of Steele was that of its attorney. In the same declaration, Steele and Hansmeier caused ML to falsely and misleadingly declare that he started AF Holdings because he believed that he could purchase copyrights for little to nothing, retain attorneys to ward off piracy, and resell the copyrights for a profit, and that the copyrights AF Holdings held would be worth significant sum if a reasonable percentage of the people who stole the content instead purchased it. That litigation was a necessary evil, when in fact the copyrights owned by AF Holdings were obtained for the sole purpose of litigation, and the copyrighted works were never made publicly available for purchase. And this is an important point. Copyright trolls are different than copyright plaintiffs in the eyes of the law. I and other people will call copyright plaintiffs trolls all day, but they're not all trolls in the eyes of the law. A true copyright troll doesn't own or exert their copyrights properly, and instead just uses their copyrights to sue, or uses too little of their copyrights to make a difference and only sues under the rest. I'm thinking of the Right Haven cases. I'm thinking of these cases. If you own a copyright, you must be using it in order to sue people for trying to infringe it. And this is this might be a good answer to the Orphaned Works Project. If you don't maintain your copyright by allowing it to be published and allowing people to purchase it legitimately, then you probably can't sue them for infringing on it, because you are not promoting the sciences and the useful arts by furthering your copyright. You're instead just trying to profit off of litigation, which is not allowed. You're allowed to profit off the litigation. You're allowed to make a whole business out of profiting off the litigation. You're not allowed to do that without also offering your copyrights for sale. It doesn't say that you have to offer them for a reasonable price or anything like that. You just have to offer your copyrights for proper use. So, where are we? On or about August 2013, Hansmeier signed a declaration in another AF Holdings case that he has never served as director, officer, manager, or employee. In the same declaration, Hansmeier falsely and misleadingly claimed he has never created a Pirate Bay account, and categorically denies ever uploading or downloading any BitTorrent files. On or about September 2013, Steele falsely and misleadingly testified that he has no ownership interest in Prenda law, has never exerted control over AF Holdings and Prenda law. On or about January 2014, falsely and misleadingly testified that they are not the trustee, that somebody else was the trustee and owner of AF Holdings and that they don't own it, yada, yada, yada. Alan Cooper sued John Steele. So I guess I didn't reveal anything there. Alan Cooper v. John Steele, he testified that I do not run or manage any way AF Holdings, that ML operates AF Holdings, that ML runs Guava LLC. In total, between 2010 and 2014, defendants and their entities received more than $6 million in copyright infringement settlement payments, causing losses totaling at least $3 million. In or about 2012, I don't know how that math works out. In or about 2012, the defendants created another company, Under the Bridge Consulting, that they intended to and did use to collect consulting fees after transferring the operations of Steele Hansmeier through Prenda Law to someone else, PD. The defendants thereafter transferred approximately $1 million of the proceeds of the fraudulent scheme to Under the Bridge Consulting and distributed those monies to Hansmeier and Steele. The defendants' use of Under the Bridge Consulting was designed in whole or in part to conceal or disguise the nature, source, ownership, and control of the proceeds or their fraudulent scheme. Statutory penalties. The defendant understands that the maximum penalties are a term of imprisonment for up to 20 years, a criminal fine of up to $250,000 or twice the gross gain or loss, whichever is greater, a term of supervised release of up to 5 years, a special assessment of $100, and the costs of prosecution. The defendant understands that the maximum statutory penalty of the second charge is also 20 years, $500,000, twice the gross gain, supervised release of 5 years, $100 assessment, and the costs of prosecution. Here's my favorite part. The defendant understands that if he were to violate any condition of supervised release, he could be sentenced to an additional term of imprisonment up to the length of the original supervised release term, subject to the statutory maximums. So he has to comply with the terms of this agreement. Let's continue. Now, there are sentencing guidelines. Let me disclaimer here. I am not a criminal defense attorney, at least not typically. If you're watching this in the future and I've become the world's greatest criminal defense attorney, awesome. But on 3/8/2017, I have not considered myself a accomplished criminal defense attorney, and I have never dealt with sentencing guidelines. So I really don't know what his final sentence is going to be, so I'm going to rely on this to tell me a little bit more about that. The parties acknowledge that the defendant will be sentenced in accordance with 18 U.S.C. 3551, which I'm assuming is the sentencing guidelines. The United States sentencing guidelines will be used by the court to determine the appropriate sentence. So the parties then specify a base level offense and then start to go into the facts of why the base offense should be raised or lowered. Based on the facts available to the government, the loss resulted from the conviction or from the offense of the conviction is between $1.5 and $3.5 million. The number of victims is more than 10. Okay, so we increased the base offense by 16 levels, then by 2 levels. This was a sophisticated means of obtaining this offense, so we increase it by another 2 levels. The parties agreed that the defendant was the organizer. The offense should be increased by 2 levels. The parties agreed that the defendant abused a position of trust, and therefore the offense should be increased by 2 levels. The parties agreed that the defendant willfully obstructed or impeded the administration of justice, and the offense should be increased by 2 levels. The parties agreed that the offense for count 17... the parties agree that money laundering automatically carries an offense level of 29. Notwithstanding, in exchange for defendant's plea, and provided that defendant does not falsely... Here we go. This is my second favorite part. The defendant agrees to not falsely deny any offense or relevant conduct The defendant understands and agrees that the defendant will truthfully testify during the change of plea hearing, that the defendant will cooperate with the probation office in the pre-sentence investigation, that the defendant commits no further acts inconsistent with the acceptance of responsibility, that the defendant complies with this agreement fully identifies all assets, and makes a good faith effort to make restitution to his victims. The defendant timely notifies the government of his intent to plead guilty, and therefore the government will reduce the offense level by 1 additional point. But this is critical. The defendant agrees to make good faith efforts to make restitution to his victims. That means that if you were sued, if you were my client, if you were somebody else's client, if you were nobody's client, if you were sued by John Steele and Prenda Law and any of these entities we've been talking about, you should be getting on the horn with your attorney. I guess I should make the disclaimer that because I said that, this video could be considered attorney advertising, but I don't consider myself advertising my services so much as saying that you've got an opportunity here to go after this guy, because if you go after him and he has to lie about it, or he doesn't he doesn't restore you to your pre experience with John Steele condition, then you have the right to try and undo this and get him thrown in jail for even longer. And heck, I don't have a right to go after him without a client, so let's do it. Somebody go after John Steele and make sure that he's paying you back every single cent that you paid to your attorney, to in settlement, in travel, in I would even go so far as to try and get him for some kind of pain and suffering or something like that. The likelihood of pain and suffering and extra damages, I don't know yet. But if you have been sued by this guy, you can come after him. Other enforcement adjustments. The parties agree that based on the information available, there are no other adjustments. Criminal history will be determined later based on information available. The parties believe that the defendant's criminal history is Category 1, but this does not constitute a stimulation. Whew! This does not constitute a stipulation, but a belief based on the assessment of the information currently known. The sentencing guideline range is 97 to 121 months of imprisonment. So that's what? Approximately 8 to 10 years in jail. The fine should range from $30,000 to $300,000. I'm assuming that that's the fine on top of any restitution. I'm hoping that his restitution requirement will be in the millions of dollars. Then after his release, a term of supervision for 2 to 5 years. And the parties reserve the right to make motions for any reason they think that there should be further departures from any guidelines. The foregoing stipulations. So the court, by the way, does not have to accept this document. I'm not assuming that it's going to, but I don't see any reason why not. But I'm also not an experienced criminal defense attorney who could tell you whether courts typically accept a document written this way. This seems to me to be well prepared, and if I was a judge reading it, I would give it its weight and probably accept it. The foregoing stipulations are binding on the parties, but not the court. The parties understand that the sentencing guidelines are advisory, and their application is a matter that falls solely within the court's discretion. The court may make its own determinations regarding the applicable guideline factors and criminal history category. If the court determines that the applicable guideline calculations or the defendant's criminal history category is different, the parties may not withdraw from this agreement, and the defendant will be sentenced pursuant to the court's determinations. So that does mean that the court could do something different, and it is possible that the judge could take this guilty plea and still hold John Steele liable or guilty for a punishment greater than what you see here. That's not typical, I don't think, but whatever. Number 8, defendant understands and agrees that the Mandatory Restitution Act applies and that the court is required to order the defendant to pay the maximum restitution to victims of his crimes as provided by law. The defendant understands and agrees that the court will order him to make restitution for the entire loss caused by his fraud scheme and that the restitution order will not be limited to the counts of conviction. Cooperation. The defendant has agreed to cooperate with law enforcement in the investigation and prosecution of other individuals, so his co-conspirators will be pursued as well. This cooperation includes, but is not limited to, providing truthful information to law enforcement agents and testifying truthfully at any trial or other proceeding, which I'm assuming includes any proceeding brought by anyone looking for restitution. If in the sole discretion of the U.S. Attorney, the defendant cooperates fully and truthfully as required by this agreement and renders substantial assistance to the government will, at the time of sentencing, move for a downward departure of sentencing guidelines. The government agrees to make the full extent of the defendant's cooperation known to the court. Great, so he agrees to cooperate in order to get a lesser punishment. Doesn't that sound a little bit like the settlements he extorted out of his victims? The defendant understands that the court will determine whether the defendant has cooperated fully and truthfully. Defendant further understands that the decision to grant or deny the downward departure is solely in the court's discretion. The defendant further understands that there is no guarantee that the court will grant a motion for a downward departure, and it will not be a basis for the defendant to withdraw from his plea agreement. Finally, the defendant understands that the United States is not obligated to accept any tendered cooperation on the defendant's part. If the United States chooses not to accept tendered cooperation, the defendant will not be rewarded for this tendered cooperation, nor will the defendant be allowed to withdraw from the plea agreement because his cooperation was not accepted. Waiver of appeal, collateral attack. Defendant understands that the law affords the right to appeal, and he agrees to waive all rights to appeal, unless the sentence exceeds 60 months imprisonment. Then, if it exceeds 60 months, defendant expressly waives his right to petition under 28 U.S.C. 2255, except for both. The defendant has discussed these rights with his attorney, and he knows that his rights are being waived. His rights are being waived knowingly, intelligently, and voluntarily. This is the complete agreement of the parties, signed Andrew Luger, United States Attorney, Benjamin Langner, and David McLaughlin, United States Attorneys. Assistant United States Attorney, and Brian Levine, Assistant United States Attorneys. And signed John Steele, Defendant. Which is where I think I will leave that on the screen. Wait, nope, I'm grabbing the wrong thing. Gah. Put this over. No. There we go. Do that. And then we'll crop its left side a little bit. A little more. There we go. And then we'll put this over here. There. Okay, guys. And gals. Now I'm paying attention to the chat. So I do want to thank all 1,800 of you for joining me to talk about these scumbag lawyers who I'm assuming have lost their law licenses as well. That's basically all I have. I would like to thank my chat moderator, Skeptic Sarah, for doing such a good job moderating the chat. Haven't had a chance to really look at it too much, so I'm glad that someone was taking care of that for me, and that's really important, that you guys have a good experience. So thank you again, Sarah. Cliff notes for the people who are joining late. I'll try and summarize. There was a copyright troll a few years ago who most of the time, attorneys, they just want to make a buck and do the right thing, or at least do a thing that they're allowed to do within the law. This attorney wanted to make a quick buck, keep it all for himself, not have to have a client to pay, not have to have any complicated facts to prove in court. And so they concocted a scheme. They concocted a scheme to upload adult movies to the Pirate Bay and other BitTorrent file sharing websites, and then track the people who downloaded them and then sue those people, often in the wrong court and under false allegations, just because the high-tech nature and novel nature of the claims allowed them a certain amount of delay before the courts would catch up to them. They got about 2 years into it before the courts really caught up to them, and when they did, the courts started opening investigation after investigation after investigation. They finally started shutting down the lawsuits that were being filed, and the U.S. Attorney and the Department of Justice Cyber Crimes Division got involved and found these guys were guilty of these offenses. They charged them, they arrested and charged them in December, and one of the principals, John Steele, co-conspirator number 1, has pled guilty to 2 of the charges in exchange for this plea deal. He'll go to jail for somewhere between 8 and 10 years. He'll have another 5 years of supervised visitation or supervised release, and then he'll have probably a $30,000 to $300,000 fine. Plus, he is ordered to restore all of his victims to their pre-lawsuit, pre-Prenda law, pre-John Steele experience, give them their money back, etc. So those people who have been affected by this should be reaching out to their attorneys, or reaching out to new attorneys if they want to, or reaching out to the Department of Justice to see what their options are. This is a big deal. There were probably several thousand victims of this man's copyright trolling, which again, we see the same thing on YouTube all the time with illegitimate DMCA takedown notices, the recent trademark takedown notices, and these things are fraudulent. And if we could just take them to court more often and show that these kinds of things were going on, it wouldn't be just John Steele that was being taken to task for committing a fraud against the court. There would be additional guilty parties, and it would probably have a bit of a deterrent effect on filing illegitimate takedown notices and strikes and etc. So, okay, was that a good summary? I hope. Can someone file for bankruptcy? No. Well, yeah, let me give you the lawyer answer. You can file for bankruptcy. It's not going to do any good. You can't get out of a criminal charge or a order for restitution for a willful act, for an intentional act, for a criminal act, or for a tortious act. Generally speaking, you cannot discharge or get rid of those debts by declaring bankruptcy. You may be able to force a collector into a payment plan. The payment plans will still pay them everything they're owed plus interest. So the payment plan doesn't necessarily help you too much. But that's about the best you could do with bankruptcy. And then bankruptcy is a huge black mark on your credit history. Well, thank you for calling me your favorite copyright attorney. I do realize that there's really no such thing as who has a favorite copyright attorney. So it is a tongue-in-cheek joke. For any of my attorney or law student viewers, I'm not trying to claim that I'm some special copyright attorney. It's just a tongue-in-cheek joke that I use. So thank you for calling me your favorite copyright attorney. Yes, what if the money's already gone, and what about wage garnishment, and how do you collect on this? That's a very good question, a very difficult question for the courts to answer sometimes. The courts will give orders for either garnishment or to seize assets, etc. That may not be necessary in this case because his his plea agreement requires him to make restitution, so maybe you don't have to go and file for wage garnishment when he should be making a deal with you to pay you back already, right, under the agreement. But yes, you would have the right to obtain a judgment and then file that judgment with the appropriate court to seize his assets or seize his property or garnish his wages if he's paid by an entity that wage garnishment sort of only works when you work for someone. If I'm paid directly by my clients, then you can't really garnish my wages. You can ask me to garnish my own wages, but you can't really take it from my employer before I get it. So, what else? Leonard for president. Yeah. I don't think people would want. I don't think people who would make good presidents want to be president, and I do not want to be president, so no. Victory by no contest. That is exactly the joke that I. Yep. So thank you for that. Let me scroll up here. Is the case U.S. v. Steele? For citation purposes, the case is. Well, that's not helping anyone. Hang on. Okay, you got the number there at least. There we go. That is the case caption. Whoop, I just scrolled all the way down. What would I do to change the current legal system if I was king? I actually kind of like the way our Constitution works, so I think I would probably keep that part. I would probably create some kind of copyright group that would be a copyright agency, maybe within the USPTO or something, but some kind of copyright enforcement agency that would adjudicate these disputes at some kind of lower cost. There shouldn't be this much money on the table when someone is contemplating making a fair use of another's copyrighted work. You should have some kind of guarantee that if you follow some steps and make a genuine attempt at making a fair use, and it turns out that you're wrong, you're not subjected to thousands of dollars in settlements and attorney's fees. I understand how we get there, how the law, we have A to protect and B to protect, and then when you operate the law, it happens to work out that thousands of dollars are needed in order to adjudicate. I get that, so we have to find some other way to make it work. Otherwise, it's going to stifle the creation of works that promote the sciences and the useful arts. Maybe patent is more sciences than copyright is, but copyright is certainly computer code. That's in there too. Article 1, Section 8 of the Constitution says copyright's primary purpose is to promote the sciences and the useful arts. So how is putting such a burden on the fair use question and on the file sharing question, but less on the file sharing question, more on the fair use question, how is that furthering the promotion of the sciences and the useful arts? On to the file sharing question, that is a really, really borderline question. Is it stealing to download a movie or music or video game from the Pirate Bay? Okay, wait, yes it is. It's got to be some kind of stealing. Let's back up. Is it automatically stealing? No. I think there's research purposes. I think you maybe want to try the game first, or you want to check out the movie first. I don't think those things should be copyright infringement, but at the same time, how does a copyright owner enforce that you downloaded a full copy of their game or a cracked copy of Photoshop or a full version of their movie or music just to check it out and then you're gonna go pay for it? So there's really good arguments on both sides. Opposing counsel would definitely tell you that it's like walking into a movie. Wow, walking into a retail store, picking out a movie or a piece of music, a CD, a DVD, a Blu-ray, a laser disc, a vinyl, whatever, and walking out with it. Um, I'll get to that in a moment, the podcast. And I don't fall on that same place. I think that walking into a video store and walking out with a movie carries a minor criminal charge and a minor fine. It's about a $200 fine, restitution to the plaintiff, and a mark on your criminal history. So should a person who walks into a unauthorized online electronic only video store and steals something or copies something that could be argued as stealing, are they guilty of thousands of dollars of copyright infringement? I don't think so. I think what they're guilty, why they get hit with thousands of dollars of copyright infringement is because the legal system hasn't been updated to deal with it. And that's the long and the short of that. So Skeptic Sarah keeps mentioning a podcast and cursing on the live stream. Thank you very much. But yes, we are starting a podcast. We did episode 1 so far. I wasn't entirely sure if I wanted to announce the podcast until we got further into an episode 2 or 3. But our first episode, we got it out. The audio seemed acceptable, and so we kept it. Next time, I'll be making sure that my audio uses this quality microphone or some other quality microphone. And we'll be doing a little further editing to edit out all my stupid uhs and ahs and pauses and crap. Because, I can't speak properly. At least not all the time. Torrenting, by the way, is completely legal before you get to the copyright infringement question. There is nothing automatically wrong with BitTorrent. Bram Cohen will defendant. There was a Freudian slip. Bram Cohen will defend it. I'll defend it. I've been called out on Twitter by the BitTorrent people for they don't like the fact that I talk about BitTorrent and piracy. But I'm not equating BitTorrent to piracy. Rather, I'm dealing with it after it happens. So BitTorrent's just a tool. And unlike LimeWire or Napster, which were pretty much created only to further copyright infringement, BitTorrent works for both copyright infringement and just for basic file distribution. If I want to put my podcast out there, I've got to have it on a server, and I've got to pay a monthly fee for that server, and I might go over my monthly allotment of bandwidth for that server, and I might be into the thousands of dollars if thousands of people are downloading my 50 megabyte podcast. So I might make it available via BitTorrent, and you go on to a peer-to-peer file sharing system, and you download a piece from all of your peers, and you've had to download 1/50th of it from me, or even less. And you probably got it faster, too. BitTorrent is very good at saturating your network connection and getting you the absolute maximum bandwidth possible. So I can't really say enough good things about the technology. It's what it enables people to do, and the lawyers then to come after them when they don't know not to download certain kinds of material. And who would know? It's not like you know ahead of time what material is going to be sued over years or months or years down the line. So not a heck of a lot you can do there. Okay. Yes, services such as World of Warcraft use BitTorrent. Yes, there are plenty of game clients. There are even movie clients that have used BitTorrent, sometimes legally, sometimes illegally. But yes, there are absolutely games that their download manager uses BitTorrent to manage the bandwidth that the developer has to pay for. And that's perfectly legal. There's nothing wrong with that, and you wouldn't be getting sued. You're in no danger of getting sued from those game developers just for using their download manager properly. Let's see, what else? How often does the court decide that a steeper sentence... I don't know. I'm not an experienced criminal defense attorney, and I don't see the inside of a federal criminal courtroom in the criminal defense side of things often at all. I don't think I've ever seen the inside of a courtroom for a criminal defense matter in the federal level. So I don't know when judges will increase the sentencing. I think the only time it would really be is when the judge has a different understanding of the impact of the crime than the prosecutor did. If the prosecutor is recommending something that's overly lenient, the judge will then think about increasing the penalties. If the judge sees any new behavior from John Steele that he or she thinks is worthy of an additional punishment, then the judge will increase the penalties. Can I speak about patent trolls a little bit? Patent trolls do this same sort of thing. They create a patent. They don't usually they don't usually use the patent for much. The patent is usually only available for licensing and only at a moderate to high price. And the patent is usually for something overly broad, like, I don't know, a method for sending messages over cellular airwaves, text messages. And they might have a patent on something that could arguably be considered the basis for text messages. So they file a patent lawsuit, but they don't just file it anywhere. They file it in a place like the Eastern District of Texas, where it almost seems, I have to be very careful with my language here, it almost seems like someone in the judiciary in the Eastern District of Texas might be corrupt in the favor of patent filers, patent holders, patent trolls, because they are relatively often overturned by the appeals court. But the non-corrupt Eastern District of Texas seems to be very favorable to patent plaintiffs. And when they file their patent matters, they often find a way to haul somebody who's not in the Eastern District of Texas into the Eastern District of Texas. So then the person's already at a disadvantage, the defendant's already at a disadvantage from having to defend in a foreign jurisdiction. Patent litigation is on the order of 10 to 50 times more expensive than copyright litigation, so I would expect a patent suit to cost between $500,000 and $800,000, and that is no small amount of money. That could be all of your profits from the thing that you created that is allegedly infringing on the patent, plus. And so individuals like the creator of X-Plane have found themselves the subject of a patent lawsuit and needed to go to crowdfunding sources, needed to make pleas for donations multiple times to try and cover. I mean, even X-Plane, which is a very popular flight simulator that even I've paid for, it's still, I can't imagine the man has hundreds of thousands of dollars to just throw at a illegitimate patent lawsuit. So when they get into the Eastern District of Texas, they have to go through an entire fact-finding mission, which is a very expensive, several $100,000 process. Then they lose in the Eastern District of Texas. Then they have to go appeal, which is often a different attorney charging higher rates and wanting many, many thousands of dollars in a retainer fee. So you're talking about another $50,000 to $100,000 retainer fee, probably at a minimum. And then there's a chance that the appeals court won't agree with you, but assuming that they do, then maybe you win. And then maybe the patent troll has to pay you part of the fees that you paid out. But maybe they figured out a way to get out of that too by then. So it's a very burdensome thing for defendants. Plaintiffs know this, and they use the system to their advantage. What do they do in the Eastern District? I don't know exactly what or how it got that way. What they do is simply they're more favorable to so if it was a black and white issue, it would be difficult to be favorable to one side and not have it be completely clear. A lot of these cases are right on the borderline. Remember, this was a patent that was overly broad, and so defendant has to come in and argue that the patent wasn't overly broad. So arguing something that's broad is too broad versus not, that's a very easy thing to have a gray line that a judge can easily fall on one side of. So it's not like a traffic accident, was the light green or red? Is this patent, does it fulfill the purposes of patent law, or is it overly broad? And then there's always the chance, let me back up here a second. In proving that a patent is invalid, you may want to prove that the patentable idea, there was some kind of prior art or prior invention. So then the defendant the burden is on the defendant to go and prove that the plaintiff's patent is invalid. So they have to go through, the defendant has to go through the fact-finding inquiry of what patents are out there, of whether this invention had been invented before, searching through hundreds or thousands of other patents to try and find something that matches. It's a big burden. It's a lot more of a burden than copyright law is, and I think copyright's a pretty big burden. Imagine Girl Talk, the mashup artist who has dozens to hundreds of sound samples in his mashups. At what point does that mashup not a transformative work, a fair use, and when is it copyright infringement? And if you've noticed, I don't think he's gotten sued for that. So either the industry is worried about that, or there's been some secret backroom deal that's not going to go down. So I forget what the question was. Did I answer the question? How does this potentially impact YouTube creators? Fortunately, it impacts them almost not at all. Only if you're a YouTube creator who also uses BitTorrent, really. This kind of file sharing litigation isn't something that goes on much on YouTube that I know of. If there is some underground BitTorrent Pirate Bay style channel that shows you how to get pirated content, I don't imagine it's going to be around very long, but go ahead and tell me about it and I'll look into it. Free speech gets even I made the mistake before and said free speech when I meant fair use. Free speech is the government. The government can't put any prior restraint on your right to speak freely on most things. They have the right to make prior restraints for safety, for health, things like that, but very, very few things that you can say. You can't yell fire or bomb in a crowded public place, or really even in a not crowded public place, that impacts safety. So that's where the government can say you're not allowed to do that. But if you apply for the proper permit and you're standing on public property and you're making your protest, you're allowed to, and the government can't say you're not allowed to talk about healthcare, or you're not allowed to talk about Donald Trump, or you're not allowed to talk about yada yada yada. So that's free speech. On YouTube and in copyright law, mostly we're talking about fair use. No one else is making a claim that there's a law that you can't say what you're going to say. They're making a claim that there's a law that you can't copy their copyrighted material, or that you can't republish, or that you can't make a derivative work. That's different. That's not First Amendment. That's fair use. And it's only fair use because fair use is a law that has enumerated rights, or rather, should I say, defenses, because fair use is a defense that you bring up once you are sued, not a right that you have that you can overcome a copyright suit without it getting started. It is only a defense to your already infringing or already allegedly infringing use. Sorry, the hat is starting to dig into my forehead a little bit. Are there hate speech laws in the U.S.? Yes, and hate speech laws are arguably on the line, but in that freedom of speech issue. Should you be allowed to say that you hate a certain group of people? Should you be allowed to spout vitriol and otherwise meritorious or unmeritorious demeaning things about groups of people? I fall on the side that you can't the government shouldn't be able to punish someone for saying those words. Maybe they can punish them for being harassing if they're otherwise stalking or following and harassing a person, but you shouldn't be able to prosecute someone for yelling a profane thing on the street without more, in my humble opinion. That said, are there groups of people who have been victimized over and over and over again? Yes, and it's hard to not want to do something for those people, and I'm not necessarily saying it's black people or it's Mexican people or it's immigrants or it's Muslims. Any group of people, trans people, LGBT, etc., any group of people has experienced some kind of that derogatoriness, that divisiveness. It's hard not to look at the most extreme cases and think that some kind of affirmative action has to be taken and some kind of law has to be made. I have a difficult time with the concept of it being an easy decision. It's not an easy thing to decide, and so yes, there are hate speech laws. How are they any good? I really don't know. That's a difficult question. Well, thank you for the hats are the second best part of this channel. The best part is everyone's favorite copyright attorney. Well, thank you. Bottom of my heart. If you had bought a physical copy of a game which became damaged and then you downloaded a ROM. You know, I have this exact same question, so I want you to know that's a very good question, and that not all these questions get really great answers from even attorneys. Strictly speaking, no, it would be copyright infringement for you to download the thing even though you previously owned a licensed copy of it. Would the copyright owner pursue you upon finding out that fact? I don't think so, but that would be up to the copyright owner. Would the court lower your fine because you thought that you were okay? Probably. At least the court would consider that or address it in an opinion, I think. Would a court agree that it's not copyright infringement? I don't know. I give it a 50-50, right on the line on that one. You owned a licensed copy, but you didn't own it in the format that you downloaded it in. But you did have the right to make a backup copy in case something got damaged, but this wasn't the backup copy that you made. It's a tough question. I think for practical purposes, everyone's probably okay. But the plaintiffs are going to see all of that downloading and they're going to think that it's pure copyright infringement. So you're encouraging companies like Nintendo to maintain their strict copyright policies. However, their strict copyright policies are what's leading you to want to download their ROMs in the first place, because they're not available on the Nintendo Switch, for example. And why not? Why shouldn't they take a few minutes per game, few man-hours per game, and port it to a virtual console and make it available, and then people can stop pirating it? Or maybe they won't, because it'll still be free and easy to get because ROMs from back then were small. Man, it's a really tough question. I don't think you'd get punished in most circumstances, but you could, and so that's my lawyer answer, is it depends. Can you go to China and pirate lots of stuff and get away with it? It certainly seems like it. I have never been to China. I don't know China very well. I do know I see a lot more counterfeit products coming out of China than coming out of the United States. I think that's a true statement. Someone please correct me if I'm wrong, but it's been my experience that China... It's not that China itself is good at counterfeiting things. I think it's that there are just some very innovative Chinese manufacturers who will produce counterfeit products. One of the most common ways I've seen it done is the very same factory that produces the primary non-counterfeit product, the genuine article, will then turn around, and when the owner of the genuine article is not looking, they will produce the same exact product off the same exact line, and they will sell it through counterfeit channels instead. Kabuki Kitsune, I do not know how much the format of the backup matters. You are allowed to make a backup. We do now have some case law, and I believe a statement by the Librarian of Congress, who was given the charge to make certain exceptions to copyright infringement under the DMCA, I think it is, because it's under the DMCA. I think it applies to digital everything, and so you're allowed to make copies, backup copies of digital things. You're allowed to make copies of analog things into digital formats. You're just not allowed to then redistribute, reuse, copy, publish derivative works, etc. Any of those backups. They're only for backup purposes and for restoring from backup purposes. If you are in Canada, can you pirate things owned by a U.S. company? Yes, and you can get sued in Canada for it. I do not know how or who is suing in Canada, if that's even a thing. You're all so polite to one another that I'm not sure that it would be worse than just, oh, I'm sorry, and you'd be done with it. But, joking, they do have copyright in Canada, and you could be sued. It would be as simple as the U.S. plaintiff hiring the appropriate attorney in Canada and filing a lawsuit that way. There would be the only difference would be that Canadian copyright law would apply. I don't know what that is. They're a party to the WIPO Treaty, the international. Oh God, I've forgotten it. I'm a freaking copyright attorney and I've forgotten what it's called. The World Intellectual Property Organization has a treaty, and I forget what it is. The Berne Convention on Copyright? Oh, geez. I'm a terrible, terrible lawyer. I've got to go refresh my memory. But assuming that they're a member of the treaty, which I believe they are, they do have many of the very same copyright laws. They have to basically implement copyright law in their own way, but in their own words, but implement it the same way according to the convention. So, yes, there would definitely be an actionable copyright case there. As far as you know, is there any case law regarding whether Let's Plays violate copyright? That's going to be a fair use question. Is the Let's Play exploiting the finished copyright work and just performing the work publicly under the guise of playing the game alongside? Could you do an MST3K movie style thing with commentary, but also while playing the whole movie in order from start to finish? No. And so I think Let's Plays probably violate copyright, and it's a matter of how much and whether the plaintiff will be willing to sue. So I'm not saying that I think that Let's Plays should disappear or anything like that, but you probably need to be working on your copyright clearance if you're terribly concerned about your copyright claims on a Let's Play. Fallen, I'll take your word for that. The notion of counterfeit is tightly bound into ancient Chinese culture. I don't know if that's a joke or if there's an actual source for that. I could see it. You know, you got to survive. You found something that someone's profiting off of, and all you've got to do is copy it. That seems to be what asset flippers do. And if you want to see more asset flipper stuff, go talk to Sid Alpha over on his channel. He's doing almost a daily show on asset flippers now. It's pretty funny. I like it. Can the UN Universal Declaration of Human Rights protect you from a law? No. I don't think so. So the UN has member states, and the US is a member state, I believe. At least Last time I checked, we have a new president, so I'm not sure of many things these days. Um, the the UN exists by the grace of its members. It does not own its members or have authority over them like you may expect. Any authority that it seems to have is because its members have granted it that and uphold its authority. If the UN Universal Declaration of Human Rights was tried to be used in a U.S. court case, the judge would probably take it no more under advisement. Um, Now I'm speculating here, so someone could correct me if I'm wrong. Someone much more experienced than me. I am not saying that it's impossible. It's a good question. Um, but usually the U.S. and its states have sovereignty over the charges and claims that they bring, and the Human Rights Declaration would be no more than a guide or what we would call judicial notice, just basically telling the judge, "Hey, judge, here's some information for you. Take it or leave it." That's about, I think, the most it really gets right now. Now, if the U.S. court case somehow if it's directly, excuse me, if it's somehow directly applied, maybe, yeah. I can't imagine the scenario. When will I cover the H3H3 updates? There were minor updates on Monday. I have to look over them to see if they're even worth covering. Certainly, there are a lot of interested people, so I could probably get away with just making a video, but I like to make my videos substantive, meritorious. I like them to have meaning and purpose to both you and to me, so let me look over the material and see if there's something I can do. Maybe it'll just be a short 5-minute video on why there's not a whole lot here, or maybe it'll be a longer video. This sentencing thing happened on Monday, so I wanted to get to this as quickly as possible. Yes, MST3K had the rights to the movies they were showing. A friend of mine tried to convince me that they didn't initially have the rights, but that's true in a sense. So it's kind of a fascinating misrepresentation. MST3K did not have the rights because MST3K was owned by KTLA, I think, and KTLA had the rights. So they didn't violate anyone's rights, as far as I know. And the new MST3K is going to be licensing everything properly, as far as I know, as well, too. I don't know about the Techno Viking lawsuit. In the U.S., being sued for using your public likeness would have requirements. Usually that's when you misrepresent using someone's likeness to endorse a product. So I'm sorry, I don't know too much about that. I'll have to look into it. How often do laws get reviewed? Well, not very often under the U.S. system right now. So there's no mandatory reviewal for laws in the United States. There has to be a law calling for a reviewal of the law. So the most that there is in copyright is every 3 years, the Librarian of Congress will look through DMCA litigation and issues and take comments and issue a ruling or a guideline on what should be considered an allowed exception to the DMCA. For example, one item that's up for grabs now is this copyright protection and technological protection measures under the DMCA preventing you from accessing your car or truck or farm tractor's engine. Let's say that you needed to work on a part of your car, or you're a tuning enthusiast, or you're a coding enthusiast, and you want to work on the code that causes your car's engine to function. You own the car, you own the tractor, you own the truck. It's yours. It's not under license. But the DMCA comes into play, and you cannot alter that software. And if something breaks, you have to go to the manufacturer, because the manufacturer has a copyright on the code, and no one else is allowed to own it to sell it to you to fix your tractor. So maybe the Librarian of Congress would issue a ruling that there was an exception that allowed people to work on the code for devices that they own themselves outright. I do not expect that the U.S. Congress, anytime soon will get around to reforming copyright law. They can't agree. Regardless of your politics, they are currently debating whether we should replace the Affordable Care Act with the Affordable Health Care Act and have them be two completely different things. So I'll leave the politics discussion at that. But I do not think our Congress is going to be focusing on anything meaningful in copyright law anytime soon. And worse than that, if we were to get their attention on copyright law, I almost assume that it would be to extend copyright terms for the Disney Corporation one more time. Just my humble opinion. European artists learn, Ava Jarvis says that artists in Europe learn by doing master's studies. Yes, a study where you copy something over and over and over again to learn it, I think that's clearly a fair use. Now, if you go and republish your studies, that's a different story. Unless they're somehow transformative, which they weren't really great studies then if they're transformative, you probably are committing copyright infringement. The underlying study, just copying a work of art so that you can get the experience of making the strokes and refining your skill, that's not copyright infringement. First off, that is not the copying we're talking about. That's copying for personal use, and you're not even really copying for that matter. You can take a picture of a painting. What you can't do is go and republish that picture, with and not have it be transformative in some way. You could not republish that picture. You could not republish your studies. Is it legal to record a phone call if one party does not know it's not being recorded? In most cases, yes. At least in the U.S., as far as I know, most places have a law that says you cannot record a conversation where the parties, one or both parties, do not know of the recording and the parties have a reasonable expectation of privacy. And there's a lot of case law on exactly what a reasonable expectation of privacy is. Is it a car? Is it standing on a street corner? Is it standing on a street corner when there's no one around and it's just the two of you having a conversation? You'd think you'd have privacy there, right? So there's a lot of that. Is it then legal to post the recording on YouTube? It's probably against YouTube's terms of service. And it's probably against the law in some other way. Wow. And then there's the question of whether you can own a copyright in something that was illegal to begin with. And so that there's a lot of questions there, actually. So Rizzori and Buck, good one. You stumped me. It's probably not entirely legal. It's definitely actionable. Is it legal? Is the posting of it to YouTube legal? Well, one, it's unethical. Two, it's morally wrong. But three, I don't know what law it breaks. It definitely, probably, those are official lawyer terms, definitely probably breaks the YouTube terms of service. When you say a let's play, Gordon Czar, when you say a let's play that doesn't include review or criticism, just a dude talking about his breakfast, you mean like talking about his breakfast while playing a copyrighted video game that he doesn't own the rights to reproduce otherwise, not under a fair use? yeah, that's not a fair use. That's probably copyright infringement. I don't know any other definition of a let's play, so I'm assuming you're talking about where he is, where a streamer or whatever is playing a video game and you're watching them play the video game. Uh, Even if they are offering commentary, that's a difficult one to call. It may very well still be considered copyright infringement if you are not providing 100% commentary and not using as little of the video or of the gameplay as possible. So that's a tough one. Yes, Let's Plays. I would say talk to the publisher or developer of the game. Find out their policy. They may have a public. They may have posted something on the internet about their policy for streaming and Let's Plays. I believe Nintendo. Someone's been telling me that Nintendo has one of those policies because I've been calling them out on being so strict. Um, maybe they maybe you could find something for whatever game or whatever you're streaming. Can you file a case against a telephone scammer? Yes, good luck finding the telephone scammer, though. The numbers they use are often spoofed. They often comply with the law by changing their phone number between phone calls, even though you've gotten called twice. They haven't violated the do not call twice rule. It's difficult, so someone has to figure that out. I am just as eager to sue the telemarketers for all of these crappy ass phone calls. They're welcome to use my normal channels to get a hold of me, and if their offer is good, I do buy stuff from marketers, but not when they call me and try to sell it to me. Only when I get it in email and it makes sense to me. Treat me like a human being, and I'll buy your product if I want to. Don't treat me like, treat me as anything other than a human being, and I'm definitely not buying your product, even if I wanted it in the first place. My take on the Disney situation, they wanted to protect their copyrights for a longer period of time, so they have money, so they lobbied Congress, so they got what they wanted. That's how democracy works, right? If you had your butt altered to look like Kim Kardashian's butt and then sold views online, would she be able to submit a copyright claim? Probably not a copyright claim, but if you were trying to pass your butt off as Kim Kardashian's butt, you might have a claim for misuse of her likeness, for misrepresentation, misuse of her public image, etc. Not the image, but rather the image, the metaphorical branding that she is. You've misrepresented her trademark, basically. You've confused people as to the source of the picture. Hello, Ilsa. My dog is getting restless. Go lay down, honey. Yes, I know I'm in the middle of a stream. Go lay down. You smell terrible. Do rights holders legally have to consider the fair use before filing for a DMCA takedown? Yes. Under Lentz v. Universal, which is up for appeal to the Supreme Court, so this could change, but as of right now, Lentz v. Universal says that rights holders must consider fair use. It is not an optional thing before they file a takedown. So if they have filed a takedown and it is illegitimate, you have a claim under Section 512F for a misrepresentation. Whether your claim is good or not would have to be adjudicated, so it's not just everybody go sue everybody, but yes, you can no longer file a DMCA claim without taking the risk of being sued for a misrepresentation. If a company asks you to do a certain task that's not in your contract, can you sue them? Especially if they do it multiple times. It probably depends on the severity of it. Breach of contract is a difficult area of law to just willy-nilly say that's a breach of contract. Is it in the contract that they can't ask you? Probably not. so it's not necessarily a breach of contract. Do you have some kind of, could you go to a court and ask them to clarify that this is not part of the contract? Yes. Will that upset the other party to the contract? Possibly. Will it hurt your relationship with that party? Possibly. So if you really think that there's a breach of contract and you really think that there's some real damage, then you need to talk to an attorney about the breach of contract. Okay. Blocking ads. Is that copyright infringement, stealing, or anything at all? Vladimir Vladinovsky asks, no, I do not think ad blocking is copyright infringement. Now let's qualify that. I'm talking about using a browser plugin like AdBlock. I'm not talking about blocking physical ads in the real world or anything like that other people put up on billboards or in magazines or newspapers. That I have no idea what you probably, besides vandalism, I don't know what that is. But no, AdBlock is not copyright infringement, and here's why. Because you make a voluntary request, send me your webpage, and then the webpage owner has a computer set up to receive that request and send a response back to you with all or part of the web page that they want to send, including links to other web pages, scripts that load other web pages, scripts that load other information, etc. And all you are doing is putting up blinders and saying, I only want to see part of this information. Now, is it a violation of the website's terms of service? And could you be sued for a breach of contract for using a website, agreeing to its terms of service, and then blocking ads in violation of its terms of service? Yeah, you could. I don't think that's going to go very well for the website, because no one's going to want to use that website anymore. But yes, you could be sued for a website terms of service violation. However, it's probably not copyright infringement of any kind under any theory that I can think of. Jack is barking. Do you think it hurts us internationally that people in other countries might be able to use intellectual property? Yes. I think it does not promote the sciences and the useful arts to have copyrights beyond a certain term. Is that term life of the author plus 70 years? Is that term life of the author plus 20? Is that term just life of the author? I don't know. I don't know where my position is on that one either. I haven't thought too hard about. That's a really tough policy question. If you commission a work, who has the copyright? Without any other agreement, the person who commissioned the work. It's called a work for hire doctrine. And so here's where it gets tricky. Your wedding photographer owns your wedding photos. So even though you hired them, that does not trigger the work for hire doctrine. And in many cases, when you hire the photographer, they explicitly put in there that Package A costs $5,000 and you own the copyrights. Package B costs $2,000 and you don't own the copyrights. And if you want more pictures, it's $100 a piece or whatever. How the law stands with the Jim Sterling and trademark takedown. It doesn't. The Jim Sterling would have had to represent Stickley's trademarks in such a way that confuses the public into thinking, not just confuses, but confuses them into thinking that he represents Stickley Games, that he is an employee or a sponsor or a spokesperson, and that he is speaking for and on behalf of Stickley Games, or that he is selling things for Stickley Games. He is not. and he never said that as far as the videos I saw. And so there is no such thing as a trademark violation for that. And frankly, they're open to a lawsuit and more. At the very least, Jim Sterling could probably get a court order to have their trademark claims invalidated. Maybe he could do something with having them removed from Steam, depending upon their violations of the Steam terms of service. And he could, of course, sue them for any damages, including his attorney's fees that he suffered from having to investigate this and respond to it. Covers of songs. Rubber Cement asks, as a musician, is playing a cover of a song copyright infringement? No. You are allowed to publicly perform a cover of a song as long as you pay a compulsory license fee under copyright law. There is literally a law that sets what the licensing fee is, and there's a website you can go to make sure you pay that fee. You are not necessarily allowed to sell copies of that performance without first obtaining permission. I would say go to the Harry Fox agency and use one of their song licensing systems, or find another agency's song licensing system and pay for a license for the song. I've personally done this. It's easy. It's not necessarily cheap, but when my choir or when I use a song that I don't have permission for, I can go and license it properly. The legal precedent that most needs to be set by YouTubers is probably a fair use precedent that I would hope that there would be a precedent set eventually. Maybe the H3H3 case will do it, that you can use lots of a person's video as long as you're providing commentary, and it will be considered a fair use. What if you use a VPN to watch videos that are not supported in your country? You're probably less guilty of copyright infringement, and you're probably more guilty of a terms of use violation, a contract violation. And so you could get sued for breach of contract. They're probably just going to terminate your stream and block that VPN's IP address. Highlight videos someone makes when playing a game that is edited. Highlight videos are much closer to fair use, and as long as you're providing the proper amount of commentary, which who knows what that is yet, you should be fine. Keyword should. Chemistry. Oh, yeah, like zero tolerance policies and things, like if I froze ice at home, is that chemistry? If I bring a butter knife to school, is that a knife? I hate that stuff. Is it a bomb to put dry ice in a plastic bottle and let it blow up? Yeah, some places consider that a bomb. Those are tough questions to answer, and I'm really impressed that you guys have got all of these such good questions. What kind of protective laws might be used from this case against copyright trolls? Actually, this very scenario of events did result in a lot of good case law that we now use to scrutinize plaintiffs when they file these kinds of things. Not only does their filing have to contain only their base allegation and not extra non-party copyright things like other stuff you allegedly downloaded. They can't publish you on a website. They don't get your email address and phone number. They're only allowed to send a demand via letter. They're only allowed to use the information to settle the case or prosecute the case. They're not allowed to dismiss the action and then bring it later just because that was more convenient for them. There's lots of case law that we got out of the Prenda law debacle. YouTube. Why on earth do they have? Stasi asks, why on earth does YouTube have a trademark takedown mechanism? Probably only because YouTube wants to try and remain in a safe space, uh, and not be subject to a lawsuit unnecessarily. Uh, YouTube probably made their own trademark takedown policy, and that's what these companies are going to try and follow. I am more or less reassured that eventually YouTube will update its policies to to account for whatever fallout happens from the trademark takedowns. Is the downloading of the video from the Pirate Bay copyright infringement, or is it only uploading and seeding? No, it's all of it. All of it can be copyright infringement. And the funny thing about BitTorrent is that it always, I mean, I guess there's ways around this now, but there's always seeding as you're downloading. So you're committing not only copyright infringement, but you're also redistributing, which is contributory infringement. And so you could get hit with 2 counts or 2 claims if you got hit with a lawsuit. And some plaintiffs were doing that till they realized that they weren't going to get any more blood from the stone, and why have to prove 2 things when you get just as much money from proving 1? Came in really late, DB. Can you give me a really brief TLDR? Yes. The Prenda law, one Prenda law copyright troll pled guilty to wire fraud, mail fraud, and something else here. Hang on, what is it? Conspiracy to commit money laundering. He'll serve, or it's up for grabs, is 8 to 10 years in jail, $30,000 to $300,000 of fines, full restitution to all victims, full cooperation with the investigation, and the whole thing is undone if he doesn't fulfill the terms. So there is a terms and use violation that you don't want to get. How powerful is a EULA in terms of copyright law? It's powerful in terms of copyright, I just said that. It's powerful in terms of contract law. So if you violate an end-user license agreement, you've violated the contract that is the end-user license agreement, and you would be subject to a claim under state law in the appropriate jurisdiction. This is... As we get towards the end of the chat, as soon as the scroll bar hits the end of the chat, it just starts bouncing, and I can't see it anymore. As a programmer, I'm often impressed by how specific and deep you understand technology. Is this something they teach in law school? No. I spent 9 years in the technology sector. I have 2 degrees in information technology, and wanted to be an electrical engineer. I consider myself an engineer because I worked in the field for 9 years, and I was working alongside engineers doing the same things that they were doing at times. I created new products for the company, I tested products, and I improved engineering processes. So I consider myself an engineer, but I do not have an electrical engineering degree. That's why I do have a technology background, though. Will I ever make a video about the Oculus Rift case? Yes, I will go over Oculus v. ZeniMax Facebook, or ZeniMax v. Oculus Facebook. It's just a matter of time. I am a practicing attorney, and I do have responsibilities to my clients. So day to day, I can't just make videos every day, although that's the eventual goal. As this YouTube channel ramps up, I will be voluntarily taking fewer clients, and actually this is a blessing for me, and this is one of the reasons that I'm doing this. Us attorneys, we struggle with this problem of having to pay the bills and our student loans while also trying to focus on the area of law that we love. And that often means that we have to take cases that we don't like just to pay the bills. I, for example, do traffic cases and family law cases, and I even have a business litigation case that I took a long time ago just to try and keep the doors open, the lights on, and everything going. Those things are way more distracting when they're not part of your core competency. I love copyright law and I can talk copyright cases all day, every day. But when I start to need to do traffic cases and family cases and business law cases, now I need to know like four other areas of law and be fully what we call Rule 1 competent in them. My Rule 1 professional responsibility to be competent in the areas of law that I practice. So as I can start getting rid of that extra stuff, I will be able to focus entirely on copyright cases. Remember, I'm from Pennsylvania, I'm near Philadelphia, and there are some copyright cases in Philadelphia, but not nearly the volume and flow that New York and LA see. So what I'm relying on here is the popularity of the channel and things to grow it that way. I have received some copyright inquiries based on the channel and the videos, and so I may have to start making sure that I do make the disclaimer that this video could be considered attorney advertising, and in some jurisdictions I do have to disclaim that. But at the same time, I feel like I'm I'm doing a public service here more than anything, trying to help everyone understand copyright law so that we're not all disadvantaged by these plaintiffs that can act with such a heavy hand. I'm being told to say hi to Sid Alpha. Hi, Sid Alpha. Thank you for joining us. Shout out. I gave you a shout out earlier when we were talking about asset flippers. So I hope that you've gained a few subscribers or two from that. Is there a slight delay in video and audio? I sure hope not. I am trying my best. The audio is piped directly into the camera. The camera is synced to the audio and out to the capture card via HDMI. Sometimes I have seen a sync issue on YouTube's end. Maybe this could be something with OBS. I'm really sorry. Last time it was a whole 833 millisecond delay, so now there's no programmed delay in there. So hopefully I don't have to do anything to sync it up. Do I watch Better Call Saul? Yes and no. I haven't seen it for a while. I think I watched through the first season and then haven't gotten to watch the rest. And I honestly... I think I remember it being good. I think I'm confusing Breaking Bad scenes with Better Call Saul scenes, though. So Breaking Bad was amazing. Okay, thank you. Audio sync is good. Why not start streaming on Twitch? I probably could. I didn't know that there would be really an audience on Twitch for copyright infringement streaming. I think this is the 4th live stream I've done. So yeah, there's opportunities here. I don't know. Can you stream to 2 services at once? I think I have the bandwidth for it, but I'm not sure if my system or OBS or whatever supports 2 streams at once. There's definitely a slight delay in chat. You'll see the chat appearing on screen way after it appears on your in your browser. No, somebody tell me about the Michael Green, the kid behind camera v. Savage, Amanda Mayer case that was served on Monday. Okay, I'm going to just copy that and I'll mark that for follow-up. There you go. It's in my notes. Will I represent Jim Sterling? You know, that's a difficult thing to say on stream. An entire half of the finding an attorney conversation is finding the attorney that you click with, that you feel a connection with, that you trust, that you're confident with. So it's hard for me to say if I would or would not represent Jim Sterling. I don't think Jim Sterling's in Pennsylvania, so I may have some issues there and may need my own local counsel or something if he's out of state. But in general, I would represent most copyright parties that have a legitimate claim or legitimate defense. I've represented small channels and small artists who have had claims on the plaintiff's side. I'm not in favor of filing mass litigation, but I'm not just a defense attorney when it comes to copyright. I also believe that people shouldn't steal works willy-nilly either. But I'm more concerned about justice, and I'm less concerned about being on the plaintiff side or the defense side. I find that it's easy to cite justice when I'm on the defense side. But then again, there are a lot of defendants who are also guilty or liable for what has been committed, and is it justice for them to get off? Maybe not. Maybe it's justice for them to get whatever the appropriate penalty is. And as my job as an attorney, of course, is to do everything I can to achieve the most positive outcome for my client. I have not watched Suits. I'll have to check that one out. I tend to avoid most law dramas because I find myself just shouting at the screen every time there's a creative license taken. Cringe Alert says he's from Macungie. That's where I'm from, Allentown. Not Macungie, but Allentown. I'm a big fan of your new Costco down there in Macungie because we didn't have one of those for a long time. The macaque, yes. Rasmus Nielsen asks about the case with the macaque. The case ended with a copyright not being protected because an animal pressed the button. Yes, that is 100% true. It is well known that a copyright only exists with a human being. Well, I say well known. I mean, obviously it's a question on the channel. But when this picture, this amazing picture, this wouldn't normally be a problem because what picture taken by an animal is going to mean anything? But this picture taken by this macaque was a perfect selfie. It was a beautiful selfie. And when it was published, I believe the photographer wanted a lot of money for it, or at least wanted it properly licensed, and there was a dispute over whether it could be licensed, but the photographer admitted that the macaque had pressed the shutter button, and under copyright law, the owner of the copyright is the one who took the shutter button, or the one who hired the contractor to do the work. And the macaque could not be hired. It didn't have the ability to consent to be hired by contract. And it did not, it's not a human being that could own a copyright. So therefore the copyright doesn't exist. That's it. End of inquiry. There is no copyright. Say a karaoke singer produced a small album using the backing track from a CD he owns. Oh, from a third party CD, not a CD that he created. That's generally not a fair use. You would have to argue that your use was somehow transformative, so much so that it has created a new copyrighted work, and this is a very, very in-depth inquiry under copyright law. You'd want to talk to an attorney, and you'd have a whole long series of inquiries and research to do because you'd be needing to prove that your use was transformative. It's a very difficult inquiry to prove. When there's a borderline case, it's difficult to say. Most cases are borderline cases. You don't necessarily see too many lawsuits over clearly transformative uses. Do you think Nintendo will get rid of their partner program? You know what? I have to look into Nintendo's partner program because I'm the one who a few weeks ago said that I didn't like Nintendo's copyright policies, and then somebody said, well, they do have a partner program now, and I haven't had a chance to figure out what that is yet. Is there a legal loophole that is keeping scammers afloat? That's pretty much what scammers exploit, is legal loopholes or impracticalities in pursuing them. Creative license in law dramas when they forget small points of procedure, skip certain important parts of a trial. For instance, when's the last time you saw jury instructions? When's the last time you saw a fight over jury instructions on a law drama? Maybe there is one. Some of them are getting pretty good, but a lot of them, they just stick to examination, direct examination, indirect examination, direct examination, cross-examination, redirect and recross, a little bit of discovery of relevant evidence. More so, they it's like half investigation and then half courtroom drama, and very, very little of it is actually exploiting the technical procedures of the court, and is rather just exploiting the drama, which is probably the heart of what people want to see anyway, but it's also the thing that annoys me most because it's not real. Favorite fictional attorney? Somebody asked me this last time. I am going to punt this question with an answer of a non-attorney. My favorite detective is Detective Columbo. And I like Detective Columbo because he tries to make you think he's real dumb, and then he hits you with that zinger where you realize that he knew what was going on the whole time and was just setting you up. And I think that was always just the coolest reveal to me. Just one more thing. I just had to ask you one more thing. And he'd always just be so haphazard, and then he had it all together. And I loved that. It was so unassuming, and he'd almost be vulnerable. He was vulnerable. He was clearly vulnerable. And in fact, half of the episodes, he would get a gun pulled on him or something, and then have to have somebody rescue him because he was vulnerable as part of his shtick. With the question is, let's say someone edits a multiplayer game client and uses it to get premium currency that is mainly gamed by using real money, and instead turns around and offers it for free, kind of like an in-game currency Robin Hood. You'd be violating the terms of service. You'd probably be violating a couple criminal statutes as well, and you'd probably get banned by the developer at best, and at worst you might be sued for the violation for the loss of monies of any in-game currency that would have been purchased or used. Hey, that would be kind of fun. I'll tell you what, if they come out with Ace Attorney for the Switch, I'll be happy to play that and do a little bit of streaming with that. I'm very, very happy with the Switch, but I don't have any previous Nintendo consoles anymore, so I don't have any way of playing that, at least not legally. RetroPie, it's on the list. It's hard to tell when when my schedule allows me to get to these things. Not only am I taking care of those things we talked about before and trying to grow the channel, but I'm trying to figure out how to grow the channel and how to make more and better videos for you. So some of this is actually learning about new equipment, learning about new techniques, watching videos on how to improve, reading your comments, researching my analytics, interacting with you in the community, and so it's just going to have to proceed at the pace that it does. But yes, the RetroPie case, long story short, is still on my docket to get to. So, Blessed Productions says that kid behind camera served Amanda Meyer Savage M 2016 with a cease and desist letter, and she has been harassing, slandering a family for over a year. Yeah, that's probably worth looking into. That sounds. I was gonna say fun. That's my dark humor. I think it's fun to investigate and read these things and find out what's going on. But I don't mean that the harassment situation is fun. Who knew the law could be fun? The law can be fun. I think education can be fun. I think learning about the world can be fun. And I was one of those students who was always upset that my teachers couldn't do a better job of making things interesting. So I hold myself to that standard, and if I'm not being fun and interesting, I do want to hear about it, and please tell me ways that suggestions, helpful, constructive criticisms as to what you think I could do to be better. Hey, Icefly, shout out to Kutztown. I do the Boy Scout Jamboree that's held or was held at your stadium every couple years, and that's always been fun. What is my opinion of software patents? You have to be very, very careful with software patents. It's too easy to, and there was this wave of patents where it was just any business process that was not patentable with a computer. And then suddenly it became patentable because you added the words with a computer. So I generally disfavor software patents and assume that code is mostly copyrightable. I do think algorithms can be patented and copyrighted. And so I do favor software patents in the form of software algorithms, where people have had to figure out new ways to detect edges or correct audio glitches or fill in whatever gaps in a photo, etc. I think those are all very important and very patentable and copyrightable things. Starting to lose my voice here. It's been another 2 hour and 15-minute stream since we actually got it working. So I'm going to start wrapping it up. Thank you all for coming. I'll answer 1 or 2 more questions. Is there a specific path to becoming a copyright attorney? No. The way I became a copyright attorney was by showing up. There are a few different paths through law school, and you could be a top member of your class and apply to the top law firms called Big Law, and you could apply to the firms that do copyright and try to get in that way. You could also apply to the jurisdictions where copyright is most often adjudicated, and you could start advertising your services in those cases. I got started by advertising my services in an area of law which nobody was doing. High-tech copyright cases. Nobody's doing high-tech copyright cases except a little bit here and there in New York and LA in big disputes. So, but these Prenda law guys and Malibu Media and what used to be about a dozen other plaintiffs were filing copyright cases in these file sharing matters around the country. And so that was something very few people knew about. I started advertising my expertise. I started showing up to the district court in Philadelphia, an hour and a half away. Anytime there was a copyright matter, I ended up meeting plaintiffs and defendants and then could speak about the cases extemporaneously. And though that led to me getting more and more phone calls, and then eventually, at some point, I was able to tone down my paid advertising, and I was still able to keep getting cases. I have some more plans in place now. I don't quite know what I want to reveal yet, but at some point I expect that I'll be able to take this thing to another level. But for right now, I'm representing defendants who have copyright issues in file sharing cases. Have I watched The People vs. O.J. Simpson? No, not yet. Having lived through that time, kind of thought he was guilty, so not surprised there at all. Kabuki Kitsune, thank you very much for all of the repeating of the questions that you were doing. I did notice that. That was very helpful. And maybe next time I'll put up like a Google Doc or something, I don't know, privately maybe, that they could be posted to so that it's a little bit easier. But hey, I learn something new every time, and so I really appreciate you doing that function for me. Okay, that sounds like a good place to stop. I will mute my microphone and put some music on for a few minutes and engage in chat while we're closing down. So thank you everyone for coming. This has been an amazing live stream, And I love doing these, and I'm just going to keep doing more of them. Have a good night, and enjoy some licensed music from Epidemic Sound. Yes, I know they're the same tunes that I've been playing. I haven't found new ones yet, so I'll just play my favorite ones, and we'll get some new music for next time.
Took some time, but we pointed out that tomorrow isn't here right now, baby. An absent mind came to roam around, captured you in a foggy cloud, baby. Standing on my toes on the edge, I'm ready to go. See it clear when the shadows are lit, I'm ready to go. paradoxical. Captured you in a foggy cloud, baby. Standing on my toes on the edge, I'm ready to go. See it clear when the shadows are lit, I'm ready to go.